Howdy. I wanted to spend a couple minutes today talking about a couple of things that I repeatedly see whenever people talk about firearms, ammunition, and specifically the law. And I call this the name one case guy. And I meet one of these guys, I'd say 3 or 4 times a year. Now, despite the fact of me actually being in the business of protecting people's criminal interest against the government of a state or the United States, I personally am someone who is a hobbyist of firearms, reloading, and all that kind of stuff. The name one case guy shows up in a comment section all the time, basically trying to state that if you want to have a Trump 2024 logo on the side of your AR-15 and use it as a home defense gun, there's a guy, usually like me, who says, don't do that, this looks bad on you. And then the name one case guy says, name one case where somebody who put Trump on their gun was prosecuted because it said Trump. The name one case guy has a fundamental misunderstanding of how criminal law works, and that's what I want to fix right now. Okay. When a prosecutor brings a case, it is based on the elements of an offense. The offense is a specific code that is written into a state or a federal statute system. The statute is fulfilled. Now, the elements of a statute might say something. A person commits an offense if he intelligently, knowingly, negligently, or recklessly, intentionally makes a decision to assault another person, and then it will define somewhere else in the statute where it says an assault is this, and a person is that, and a weapon is this, and a firearm or a knife or whatever, and it goes into there are things that have to be pieced together. And when a prosecutor brings a case together, they use something called an information or an indictment. What that does is it alleges a certain number of facts that fulfill each and every one of those statutory elements. Now, whenever you have a filing of a criminal case, the indictment is the only thing that's ever really given to the public. What that means is that if the case should go to jury trial or plead, you're not really privy to any of the information unless you were there inside the courtroom. So that means that the only information that you would be able to get when you name a case is what information is written in the indictment. And in most indictments is written that on or about this date, XYZ person did then and there in the aforesaid county murder XYZ person using a deadly weapon in accordance with the state law. And that's all they have to write. And so what you have is that you can have a murder case and then you don't get any of the defense's information. You don't get any of the self-defense stuff. You don't get any of the important information about the circumstances surrounding the case. They don't even allege a series of facts. It literally just says what the person is accused of. And so the name one case guy, though, says that we should be able to just look up information and find out what arguments were made. Now, there's something called a jury charge, which is read to a jury at the conclusion of the evidence of a trial after the arguments have been made. In many states, it's obviously different, but a lot of times the jury charge is then handed to the jury, and then in the state where I practice, then the state makes its final argument and the defense makes its final argument. And they want to explain the charge as it's been written. Even the charging documentation doesn't have the facts of the case, nor do they have the facts of the argument. The argument is what gives the state the ability to raise issues. And so when somebody wants to raise an issue of the Trump 24 gun or the Bible verse on the gun stock kind of thing, that's all presented during the trial. That's not presented during any filing. And so you'll never find a filing that describes what the state's arguments are going to be. And prosecutorial privilege allows them the ability to charge a case based on any fact that they want, as long as it fulfills the elements of the offense according to the statute. And I know this is dense legal language, but this is why the name one case guy is so prevalent. There is not a repository of information in which you can actually pull up convictions by jury based on type of gun. No. But what you have to do is listen to criminal defense experts, criminal defense attorneys, law enforcement agents and people who have actually sat through hundreds, maybe thousands of jury trials. Or maybe perhaps somebody who worked for the judicial system at some point and perhaps spent some time with prosecutors in the gang units or prosecutors in homicide. Trust me, the types of information that is brought out during a jury trial is way different than you'd imagine it would be. The type of ammunition, the speed of the ammunition, ballistic information from the ammunition, the type of gun, the distance from which one was shot, the wound ballistics, burns on the skin, all of these things come up, okay? And so when somebody says 44 Magnum is too powerful and the prosecutors will use that against you, do you know why? It's because that's actually been used as a case. I want people to look at the Kyle Rittenhouse case. One of the interesting things is that the M4 assault rifle was designed to shoot 55 grain ammunition, because that ammunition at the speed that it travels at was determined to have tumbled inside of the body and does not violate the NATO conventions or the Geneva conventions for expanding ammunition that is designed to cause unnecessary pulverization of flesh and tissue, right? The prosecutor in the Kyle Rittenhouse case used the fact that he used full metal jacket ammunition, which is designed to kill in a specific way. They tried to bring that up to a jury. However, if you search under acquittals or something for Kyle Rittenhouse in this famous self-defense case, one of the things that comes up is that you will not find anything about full metal jacket ammunition. Yet, I watched that trial, that entire trial. And the prosecutors made sure that the use of full metal jacket ammunition was brought up, that the prosecutors used it to win their case. Prosecutors may not believe what they're actually saying, whether or not Trump 2024 on your gun makes you more or less likely. However, what they will do is that they will try to get a jury in a room who is going to listen to whatever the prosecutor says and make a decision on whether or not to circle guilty or circle not guilty. What that prosecutor is going to do is use every piece of evidence available to them to make it seem like a defendant is more likely than not guilty. And now, of course, their standard is beyond a reasonable doubt, but they're hoping that the jury will just look at a person and say, yeah, he's guilty. So ultimately, in this situation, they're going to use anything they can. If they believe that a person is crazy and is prone to violence, and they have evidence that they believe would show that, you bet you're behind you're going to hear it. And if it's evidence of using hand-loaded ammunition because it's unregulated and unverified, trust me, there's an argument that can be made against that. And I've heard prosecutors make it. Using a rifle instead of a pistol, using a shotgun instead of a pistol, using a pistol instead of a shotgun, right? Anything that you say, using a gun versus a knife, using a knife versus a bat, using a bat versus bear mace, anything that you did or didn't do that will help a prosecutor secure a conviction is going to come into the case. So I don't care about this whole name one case thing. The second thing that you need to learn about the whole name one case thing is that there, again, as I had said before, whenever you find a case and you name a case, those are all appeals cases. And those are cases that went before an appeals court based on a procedural issue that happened during the trial or during a part of the pretrial situation in which an appeal was granted. So you are never going to find operative facts of a case in the whole name one case scenario. You're only going to find cases in which the trial court and the appeals court disagree on whether or not a piece of evidence should or shouldn't have been admitted. So they don't get into the substantive evidence at all. They only get into the actual procedural aspects of the law and if the law was correctly applied or if the standards of review were properly met. So anytime someone pulls this name one case thing, ask them where would we go and find a case? Where would we possibly go to find reasons for conviction? And then just wait. Okay, can you tell me where the repository of reasons for conviction are? Otherwise, though, because there is no repository, they're going to say the fact that there isn't a repository is the whole reason why the prosecutor wouldn't use this. I'm telling you, as somebody who deals with prosecutors every single day, they will use it, and they'll use anything that they can. It's literally in their job description to prosecute, right? And if you think that prosecutors are the most ethical, people, you have to wonder. I think prosecutors are just as ethical by number as attorneys. as any group of people, as any group of professional, as bankers, as policemen. If you think that there aren't dishonest prosecutors out there, you're wrong. Or if you think that there are prosecutors that will do anything they can to secure a conviction, even if it goes against their own beliefs, even if they know down deep in their heart that a shotgun was a perfect tool for this case, they will still say a shotgun with that double-aught buck is overkill, and it was designed to maim, and it was not meant to stop the threat, and he is a murderer at heart and an evil, wicked person. So here's what I want you to do. If you think that there is a way, and if you'd like to prove me wrong, please, I welcome it. But as a scholar of the Second Amendment and as a scholar of criminal law, I believe that there is not really a place in which someone can prove to me that there is a place where you can just easily search what it was that made a jury decide. As a actual defense trial attorney, one of the things I can tell you is that the opportunity to talk to a jury itself is so rare that we will stop talking to our clients, stop shaking hands and get congratulations to try to catch the jury before they leave the courthouse, just for the purpose of asking them, hey, what was important to you in this case? What helped you make your decision? Not for anything other than the fact that we desperately want that information. We want to get inside jurors' heads. What made you, what arguments were important to you? And so, when attorneys themselves, trial attorneys, have such a hard time getting inside of the juror's head, what makes you think that there is a repository of information leading you to know why a jury made a decision? What I can tell you, though, is that there have been dozens and dozens and dozens of cases in your area, every single month, maybe every single week, in which prosecutors have gladly brought up the fact that somebody had a gold gun, or that somebody had Trump 2024 or the Punisher logo on their gun and showed it to a jury, or showed it to defense counsel to show them that they're going to make your client look like an insane person. So what I'm trying to say is there's a good reason why we say use standard ammunition. Use the same ammunition that the police use, because that is ammunition that everybody understands. It's meant to protect our community, so it's good enough for me, right? These are arguments that cannot be refuted. What we're not looking for is, I'm not saying that you're going to prison if you use hand loads, but what I'm saying is that it's harder to explain using hand loads when you can use the same ammunition that policemen use to defend our communities. Do you see how the argument right there is harder to refute, or at least for the defense attorney to immediately shut it down, rather than letting the jury sit there and think about it, okay? So these are important things that you need to know. I'm sorry I'm taking a long time talking about this, but it is a dense legal issue. But I want you to know a couple of things. The name one case guy is he's just talking out of his rear end, okay? The whole name one case thing. And if you say that to somebody and name one case, you're that problem, your problem. And you are probably likely to make a very foolish legal mistake, and you may be the guy who is going to be sitting there in the defendant's chair, and your attorney is going to try to have to undo some damage that you have done to your criminal case by saying dumb things like that. So I hope everybody's doing well. Nothing that I'm saying here is to be taken as legal advice. I'm an attorney in a very specific area. None of you are my clients. So just make sure that everything that you hear goes through your own attorney, and talk to your attorney about the laws in your own specific state, because that is very important. Make sure that you are always obeying the law. Thank you.